As of January 1st, 2026, the strict new mandates of Tennessee's Senate Bill 1864 are officially active law. This legislation immediately impacts the livelihoods of current guards, new applicants, and security company owners throughout the state. SB 1864 significantly expands character and fitness requirements, moving the industry toward a stricter regulatory framework. The legislature designed these new rules to aggressively vet out high-risk individuals, elevating professional standards and protecting the public. Ignorance of these updates is not a legal defense. Failing to understand exactly what the state now requires means risking the instant loss of your career or your business. The most significant threats to your license fall under a new category of strict behavioral disqualifiers. Under the revised code, any stalking conviction on your record automatically blocks you from holding a license, regardless of whether the court classified it as a misdemeanor or a felony. If you are already working in the field, you are not grandfathered in. This specific disqualifier applies retroactively the moment you submit your license renewal. The state has also implemented an abuse registry rule. Being listed on an abuse registry here in Tennessee or in any other state results in immediate disqualification for as long as your name remains on that list. For those carrying a weapon, the legislature established a separate, significantly stricter set of parameters specifically targeting armed security guards. If you are subject to an active order of protection, a bond condition, or any other court action that legally prohibits you from possessing a firearm, the state will instantly strip your armed registration. Senate Bill 1864 completely closes past administrative loopholes. A single behavioral lapse or temporary court order now permanently bars you from working in the armed security industry. Beyond immediate disqualifications, the law introduces a highly specific mechanism for individuals with certain past convictions, a mandatory 5-year post-sentence waiting period. The 5-year countdown does not begin on your conviction date. The clock remains frozen until absolute completion of your sentence. The state defines this strictly: total release from incarceration, the end of all probation, and final payment of all fines and financial restitution. A simple misunderstanding of when your sentence was legally finalized could result in applying years too early, leading to an immediate rejection from the state. To protect your license before your next renewal date, you need to execute a precise compliance plan. First, pull and review your own criminal record. You need to identify any newly disqualifying offenses immediately, particularly those involving stalking or domestic issues. If you have a past conviction, map out your exact eligibility timeline using that strict 5-year completion rule we just outlined. Should you find any ambiguity about how the 2026 rules apply to an old charge, seek out specialized administrative licensing counsel immediately to clarify your standing. And for security company owners, the burden falls entirely on you to continuously vet your personnel against these updated standards, or you risk severe negligent hiring liability. Navigating this complex regulatory landscape requires professional support, starting with updating all of your required training and certifications through Alliance training and testing. Maintaining your career under these new rules requires proactive compliance. Enroll in Alliance Training and Testing's state-certified online or in-person courses today to secure your future in the industry.